the World Day for Social Justice. So, right, and we brought out a team for the program. We tagged it "Power of Youth Activism: Driving Social Change in Nigeria." And I want to welcome everyone. To this program. I'm actually waiting for one of our speakers who might join us so soon. Please bear with me.
I'm in toilet.
Hello. Okay.
Good evening, everyone. Hello, is anyone there? Good evening.
Please mute yourself. Please mute yourself, please. You are here. Mute yourself.
Okay, sir. I am actually greeting the COPDEM National Chairman. I am greeting him. Good evening, sir.
Yes, good evening, our Imo State Chairman.
Okay, we are pleased to have you on board, sir. Okay, to kick off, we have one of our speakers available right now. He's a senior colleague that has just graduated from the Faculty of Law, Imo State University. Senior colleague, sir. Good evening, sir.
Good evening. Thank you. I'm with you.
Okay. So, like I said, today is World Day for Social Justice, and I decided to look for a way to, celebrate today being a World Day for Social Justice, and I carved out a team for us to talk about and deliberate on, which is the power of youth activism driving social change in Nigeria. So I think I would leave the stage open for Senior Courage to do justice to this team. And probably before he's done, our second speaker would join us. Senior Courage, you have the stage, sir.
Okay. Madam. Sandu.
Okay, thank you very much. Thank you very much. Good evening, everyone. It's my pleasure to be here tonight. And I believe by the end of the lectures of the day, we shall fundamentally go home with something. I would like to start by introducing myself. So I am Egono Courage Chinedu Chid, a law graduate of Imo State University, Owerri. And so to say, I was impromptu given this opportunity to have this conversation, but as God may have it, from my research, I had gathered out one or two things which would be of beneficial impact to us all today. So, the topic we have at hand is youth activism as it relates with driving social change in Nigeria. So, I'll try to break this down as much as possible, and I'll try to give you the nexus between this topic and constitutional issues in the country. I'll try to, as much as possible, make you understand this thing from the constitutional aspect and from various aspects as well. So to say, before we dive deeper into this topic, I would like to make us understand that the topic is a human rights issues. It has to do with human rights. It is a fundamental human rights issues. Let me not say just human rights, because there are human rights and there are rights that are classified as fundamental. So it is a human rights issues, and it is quite an interesting topic, so to say, to deliberate on. So I would like to take us into appreciating this topic from a jurisprudential point of view to start with. Activism, as we know, did not start today. It has, since time immemorial, been a thing of societal effect. Sometimes, some days, activism are termed good. Sometimes, depending on the intention of those activists, activism are termed bad. Most social change we have today around the world has been products of activism, because without activism, we wouldn't be where we are today. Human rights, so to say, is a product of activism. The rights you and I bear today, which are called inalienable rights, the rights you and I bear today, which are fundamental to our existence, which is obtainable as a common standard of humanity all around the world, not just in Nigeria, they are products of activism. So the concept of activism is quite deep and broad, but we are going to be narrowing it to youth activism. Back in historical periods, different legal systems had surfaced, different world powers have surfaced. And over time, we see how the struggle for a just and social and equitable life had always been predicated on activism. For instance, the French Revolution was predicated on activism. The way the United States gained independence was predicated on activism. The United States, as we know it today, which gained independence on the 4th of July, was predicated on activism. Without the United States Revolution, they wouldn't have been independent today. Nigerian independence today is a product of activism. We had the Pan-Africanist movement and the rest of them. So this goes a long way to tell us that the concept of activism can drastically and fundamentally affect societal issues, affect societal structures, cause reform, and have social change and impact on people's lives. So now, bringing this thing home, the first country in Nigeria, in Africa rather, which gained independence, in the West Africa, so to say, which gained independence, was the Ghanaians. And when they gained their independence, they fought for other countries to also have independence. From 1957, Nigeria and a lot of countries followed suit 1960. And they were of the view of forming an African continental government, all based on activism. For the period of what? Just one sole purpose, eradicating all form of colonialism in Africa. And not just that. If we bring this home to Nigeria today, you see that Nigeria has been a product of different activism. The institutions we have today, the legal system we have today, the legislations and statutory provisions we have today, judicial precedents, all these have been products of activism. So activism is just, call it one basic tool for social change. It is a fundamental tool for social change. As a matter of fact, there cannot be social change of a large impact without activism. One person alone can hardly make a social change. But that person's opinion, if bought by a community, can drastically cause a social change. If you move forward now, we bring this to the Constitution. The Constitution, according to Section 1 of the Constitution of the 1999 Constitution of Federal Republic of Nigeria, made us understand that the Constitution is supreme. The Constitution is the number one source of law in Nigeria. It has 3 subsections, and the subsections, each of them had fundamental emphasis on something. Section 1 says this Constitution is supreme, and its provisions shall have binding force on all persons and authority throughout the Federal Republic of Nigeria. So if you look at the provisions of Section 1, Sub 1 of the Constitution, it emphasizes stricto sensu what we know as rule of law, whereby nobody is above the law, because it says the Constitution is supreme, and it is supreme over all persons and authorities throughout Nigeria, including all authorities. All authorities here, we should be thinking of it as governmental authorities, the legislature, the judiciary, the executive, and stuff. So the Constitution is supreme to them. Everybody is under the law. So nobody is above the law. We all share equality before the law. You move forward to subsection 2 of that same section. It says, the Federal Republic of Nigeria shall not be governed, or shall any person or group of persons take over the control or government of Nigeria or any of its parts thereof, except in accordance with the provision of this Constitution. This subsection 2 is not much of an emphasis of today. It's not much of an emphasis we have to make. This emphasis can only be made here when you have things like coup d'etat, or when you have things like a non-constitutional change of government. So you see, people could be lured into activism because the government of the day is not the government the people want. It's not a democratic one. So subsection 2 says that no person in Nigeria shall be the leader of Nigeria or shall rule Nigeria if that person has not followed the constitutional provisions. Now, subsection 3 should be another emphasis we should hold on to. It says that if any law is inconsistent with the provisions of this Constitution, that this Constitution shall prevail, and that other law shall, to the extent of inconsistency, be void. And this is what we call the supremacy clause of the Constitution. Section 1, Sub 1, and 3 forms the supremacy clause of the Constitution. The Constitution is supreme, Section 1, Sub 1. Then Section 1, Sub 3 tells you that if you make any law that is inconsistent with the Constitution, then that law shall be void. In other words, if the Constitution says A and there is a law made that says B, then that constitution, that law rather, since it is in conflict with the constitutional provisions, it shall be rendered void. It shall have no effect. A good example is there's this fundamental right guaranteed under the Constitution, under Section 44 of the Constitution. Section 44 of the Constitution states that you are entitled to compensation. You are entitled to compensation by the government if the government takes your land from you. Section 1 of the Land Use Act tells us that all land belongs to the governor. All land in every state belongs to the governor. Then Section 44 of the Constitution says that if the governor takes any land from you, if the government deprives you of your right of occupancy, then you are entitled to compensation. Now, Section 46 of the same Constitution tells us that if any of your rights under Chapter 4 of the Constitution is breached, that means that includes your right to compensation. If it is breached, then you can seek a high court for redress, a high court in that state where that thing happened for redress. If you go to the Land Use Act, remember the Constitution says you are entitled to compensation if the governor revokes your right of occupancy from you. Now, the Land Use Act has it as its provision that under Section 47, that a state high court, no court can entertain matters pertaining to how somebody is compensated or whether somebody should be compensated or not. Now you see that, remember the Constitution says you have a right to be compensated. And he went to Section 46 to say, if that right to compensated is violated, go to a court for redress. But there is this law made that regulates land in Nigeria called the Land Use Act of 1978. Yes, 1978. So that Land Use Act says that you cannot go to a court for compensation. That Land Use Act is inconsistent with what the Constitution says. In such situation, Section 1 sub 3 says if there is any law that is made, whether federal, state, or local law, if that law is inconsistent with the provisions of the Constitution, that law should be void. So over the years, there's what you call judicial activism. Judicial activism occurs when the courts or the judiciary themselves are engaging in activism, are engaging in reforming the law. So the judiciary has over the years stated that anybody whose right has been violated to compensation can still come to the court. We will give him a remedy, irrespective of what the Land Use Act says. As a matter of fact, the court has declared that section of the Land Use Act, Section 47 sub 2 of the Land Use Act, void because it is conflicting with the Constitution that says you can go to court. How can the Constitution say go to court for redress and the Land Use Act say you cannot go to court for redress? So this is contradictory. They are contradictory. I'm trying to lay a foundation of, I remember I told everybody that the topic at hand today is a human rights issue. So since the human rights issue, I'm trying to lay a foundation from constitutional basis. For us to understand that in order to engage into activism, there are certain constitutional measures that must be taken for it not to be declared void, which we shall see subsequently. Now, moving forward, if you go to Section 14 of the Constitution, Section 14 of the Constitution, remember Section 1 of the Constitution says the Constitution is supreme. So there are two key concepts in law, even in government and in political affairs. One is the concept of supremacy. The other is the concept of sovereignty. So supremacy and sovereignty should not be confused to mean one and the same thing. In the Constitution, Section 1 sub 1 says the Constitution is supreme. If you go to your same Constitution, Section 14 of that Constitution, we are entering this topic now at hand, practically. Let us extract it and operate on it and dissect it from constitutional purview. Section 14 of the Constitution, it is under Chapter 2 of the Constitution. It says, subsection 1 says, the Federal Republic of Nigeria shall be a state based on the principle of democracy and social justice. Remember the topic at hand is social, it has to do with social activism. So, in other words, where there is not a balance, there is no balance of social justice, activism would come into play. there are definitely going to be times where people would engage into activism, because primarily why people engage into activism is because of social justice, lack of social justice. Now, if you look at that same section 14, you go forward, dive deeper into it. Subsection 2 says, it is hereby accordingly declared that paragraph A now mentioned that sovereignty belongs to the people of Nigeria, from whom government through this constitution derives all its powers and authorities. You see, the constitution made us understand that the concept of supremacy belongs to the constitution, but the concept of sovereignty belongs to the people. So the people are the sovereign ones. The constitution is the supreme law of the land. In other words, it's the autochthonous law of the land. It is the organic law of the land. It emanated from the people, because the preamble of the constitution says, we the people of Nigeria, having hereby declared to be one indivisible and indissoluble country or nation under God, do hereby give ourselves this constitution. So it is the people that made this constitution for themselves. That is why it is still the same people that can reprobate this constitution that has been approbated. In other words, this constitution is supreme over everybody, but its provisions can be amended. That is why you used to hear the concept of constitutional amendment. The constitution was amended. The one we are using today is the 1999 constitution as amended. So there was the 1979 constitution before the 1999 constitution. That one was defective. That is why it was amended to 1999. So the people can amend the law, but no matter how many times they amend the law, they still reserve the concept of supremacy for it under section 1. That is supremacy clause. Every constitution of Nigeria had always asked section 1 as its supremacy clause from time immemorial. So you come to section 14. It says sovereignty belongs to the people. That is to say, remember I laid the foundation. Section 14 sub 1 says Federal Republic of Nigeria shall be based on the principles of democracy and social justice. So, and it now said that sovereignty belongs to the people of Nigeria, right? From whom government through this constitution derive all its power. So the powers of the government were given to them by the people. That is why we elect our leaders. We practice democracy. So because of we practice democracy, we elect our leaders. So the section 4, 5, and 6 of the constitution, which states legislative, executive, and judicial functions of the government, they are all elected personnel. Apart from the judiciary, which is appointed, the executive and the legislatures are always elected. So we give them the power to act. That is why we can also deprive them of that power to act when they are defective, because of the principles of checks and balances. If the president is going astray, the court can call him to order and declare his acts unconstitutional or travel. If the president is going astray and the court cannot do anything, the National Assembly can impeach him, because 3 of them are watchdogs to themselves. The National Assembly can impeach him pursuant to section 143 of the Constitution, which is not the topic of discourse for today. So I'm trying to make you understand that the Constitution said we shall be based on social justice. We shall practicalize principles of social justice. And it said sovereignty belongs to the people. So this sovereignty belonging to the people is usually invoked in instances where we lack social justice. You see, the people engage in activism. So the people would always engage in activism. The people would always engage in activism to make sure that the government of the day are accountable. Then, still under that section 14, subsection 2, paragraph B says, the security and welfare of the people shall be the primary purpose of government, which means the Constitution grants the government one primary purpose. Every other purpose is secondary. Every other thing, currently, our president changed our National Assembly. It is secondary. It is not why we are here. Sorry, our president changed our national anthem, so to say. It is a secondary matter. The primary purpose of government is the security and welfare of the people. That is why when you see countries which their government has not guaranteed their security, their government has not guaranteed their welfare, the people start protesting. Thus, the concept of protest, peaceful protest, which sometimes can result to violent protest, because the security of the people is not guaranteed. There is high insecurity in Nigeria. That is why the level of protest is always high in Nigeria. The welfare of the people are not there. It's not there. How can minimum wage be competing with bag of rice? That means for somebody to have bag of rice in his house, he will have to hustle for like 5, 6 months before he can buy bag of rice and everything to cook the bag of rice. Because you cannot use a whole 1 month salary minimum wage and buy bag of rice now. It doesn't make any sense. There's no logic in it. So the welfare of the people is at risk. It is in jeopardy. So that is why people protest, because we are trying to protest to drag the attention of the government to feel what we feel, for them to know that we are the ones that elected them there, and we are not animals. We ought to have a little minimum standard of human right we ought to have is the right dignity of a person. We ought to have dignity. Now, if you move forward again, across that constitutional provision of Section 14, you see Section 15, which provided for political objectives, and Section 16 provided for economic objectives. So the political objectives and economic objectives all are provided for in the Constitution. That means the government owes us some political activities. The government owes us some economic activity. Making economic activity here in the sense that they make sure that the resources in Nigeria are harnessed and distributed evenly amongst all of us. But because resources are not always harnessed and distributed evenly, particularly when you talk about the oil aspect or sector of the country's economy, you see that no wonder we always have a high level of oil spillage and what you have in the Delta area, because the people who owns those oil feel cheated. They are marginalized. You cannot come take my product and then distribute it to everybody in the country and give me less than 10% of everything you took from me. The people feel they are not evenly represented. The government, most times on their appointment, they appoint with lack of federal character. They don't appoint to be in line. The appointments are not. Buhari did it at his own time. People he appointed as ministers mostly were from the north, and people question that. It doesn't reflect the federal character of the constitution, which says the appointment should be from different regions of the country and stuff like that. So people would always protest whenever they feel their right is being violated. Whenever they feel their right is being violated, they would always protest. Now, Section 17 of the Constitution is what now talked about social objectives. It talked about social objectives on its own. So Section 15 is political objectives, 16 is economic objectives, 17 is social objectives. And it says, Section 17 sub 1, Section 17 sub 1 rephrased or restated Section 14 sub 1 of the Constitution, that Nigeria shall be based on principle of social justice. Section 17 sub 1 says that the state social order is founded on the ideals of freedom, equity, and justice. This is what Section 17 sub 1 says. That the state, Nigeria, the state here should be used in the context of the country. It is founded on the principles of, or on the ideals of freedom, equality, and justice. That is to say, for us to say we have our social ideals being met up with, we must have freedom. That is one. We must have guaranteed freedoms. We must have equality. Nobody is above the law. Buhari's son should be treated as I am treated. Not Buhari's son. If you go to class, they pass him in class. And me, because I'm a son of a nobody, he give me F. No matter how hard I try. These things are inequalities because of nepotism and favoritism. So, and also justice. Section 17 restated or married itself with Section 14 sub 1. Section 17 sub 2 went further to tell us that every citizen shall have equality of rights, obligations, and opportunity before the law. In other words, every citizen of Nigeria. This one now is only limited for Nigerian citizens. In other words, aliens don't have equality with us. No wonder aliens could be deported back. If they violate our internal laws, they could be deported back. You understand? Or extradited whenever they have committed offenses, which requires their country to prosecute them. So if you gallivant through section 17 sub 1, 2, you would see that it's talking about social justice. 2b talked about the sanctity of human person shall be recognized and human dignity shall be maintained and enhanced. So you see that dignity I talked about from the onset. The minimum, every human right, I will educate you on that subsequently. Every human right you have today, human dignity is the precursor of all human rights, because dignity means respect. Where there's no respect for somebody, then you cannot recognize that person as having right. If I don't respect you, I will not recognize you as having right. So because I need to be respected, that is why I have certain things called rights under law, because the law respects you. You are born with certain rights that nobody can take away from you, unless the state or the law states contrary to that. So it says, section 17 sub 2c says governmental actions shall be humane. That means the activities of the government shall be humane. It shall be based on human feelings and emotions. Nothing shall be extraordinary to humane. Nothing shall be beyond humane. We shall not be subjected to hard-working conditions. We shall not be subjected to torture. We shall not be subjected to different things. So we shall be given, fair treatment and equal treatment under law. Going further, if you see that same section 17 sub 2e, it says that the independence, impartiality, and integrity of courts of law and the easy accessibility thereto shall be secured and maintained. This one, I wouldn't say empower, assures us that the courts are going to be umpires of justice. No wonder some people say judges are ecclesiastic beings. There ought to be umpires of this common phrase that goes around in the country. It says the court is the last hope of a common man. This section 17 sub 2, it tells us that court shall be impartial, the integrity of court shall be kept, and the easy accessibility to court is one thing on another end, because some people may not have access to court because of social or societal standards or behaviors or constraints. They may not have access to court. I may have a serious human rights issue, but because I am poor, poverty is a deprivation of human rights. Because I am poor, I can be deprived of going to court to enforce it, because court is not just something you go to and say, "My lord, may I objection, my lord, my right." No, everything you do in court, you file motions, you file petitions. Everything is with money, and a poor man, when I mean poor, wretched man, cannot even meet up with that standards, because he's going to ask himself, has he eaten 3 square meals a day or even 2 square meals a day? Talk more of getting money to go to court, and they'll start thinking about it as, if you go court finish now, you know, go still win your case. What is the essence? And you see, people, that is why some people, when they have actions, they prefer recourse to self-help. They prefer recourse to self-help and jungle justice than to go to court, because sometimes they believe court is expensive to run, which I wouldn't lie, in most instances, depending on the nature of the case, it is. So having noted all these things in section 17 of the Constitution, giving you a foundation that the Constitution is supreme, I made you understand that the Constitution, if a law is inconsistent with it, it is void. I made you understand that the topic for this course, since it has to do with social justice, I'm educating you on social facts obtainable in the Constitution, so that you have a bearing of angle and distance to navigate your path towards understanding how to make an inquest or make a movement for activism. So you wouldn't make activities that are contrary or contradictory to what the constitutions are saying. So you have a right to engage in activism, which you shall still see that is guaranteed. However, all these foundations I've given, so to say, and all the sections I've mentioned, section 14, 15, 16, and 17 of the Constitution, these rights are impotent in nature. Impotent in nature. They are impotent in nature. Impotent in the sense that they are not enforceable in courts. They are not enforceable in court. They are not enforceable in court because section 6, subsection 6c of the Constitution says they cannot be enforceable in court. Now, if you look at section 6, subsection 6c, we talk about the Constitution says that section 6, it says the judicial power of the Federation shall be vested on the courts, to which this section applies. Then that section 6 of 5 listed courts of superior record in Nigeria, starting from the Supreme Court to its lower in hierarchy, which is the Court of Appeal, to Federal High Court, to High Court of the FCT of Federal Republic of High Court of the Federal Capital Territory. Rather, you have Customary Court of Federal Capital Territory, the Sharia Court of Federal Capital Territory. Now go to state high courts and the rest of them till you see that it listed courts of superior court. It tells you that judicial powers of the country can go to, as in, are vested in the courts, so to say. And when your rights are breached, you can go to court. But that same section 6, we say judicial powers of the country are vested in courts.
Hello, Sakorej, are you still there? Okay, I think he's having network issues right now. Okay, in his absence, maybe while we wait on him, I want to invite the COPDEM national chairman on stage right now. If he has anything for us, anything at all to give us. Sir, please, do you have anything for us, sir?
It's like our guest has not paid his network dues, or some form of injustice is going on. How can we subscribe and then we buy data after 200% increment? Then we don't have steady data to even have a decent conversation. So we need to create activists to step out, ask the right questions, demand answers by virtue of our Constitution. Good evening, all. It's nice to actually listen to fresh minds deliberating. I don't have much to say, but I feel, let me just say hello to everyone. And I'm very, very impressed. It reminded me of the days, those days we were in school, whether it is corporate law, 101 business law, you know how it sounds. It's always interesting. And it gives you boldness. You know, from an informed position, it makes that, not ego, that energy, that positive vibe, that it is possible. People are afraid to venture because they are not sure if they are contravening the law or working, in tandem with the law. So every session that has to do with knowing what your rights are, knowing what activism is all about, is a very informing session. And that's why the lawyers, they move with a flair and this kind of confidence, is because they are talking from an informed perspective. So it will be good. Imagine if half of the Nigerian youths are aware of these rights that have been enumerated by our guest. Imagine how they would speak about what should be done. When the Land Use Act says you cannot go to court, we didn't know it was contrary to the Constitution. But when you begin to discuss with people, you broaden your ideas. Quite a number of maybe folks may not be on this call. Some of them may be in some clubs, some of them may be just taking a walk, having a dance at home, some taking dinner. But fora like this is an avenue for an increase, like free increase in knowledge, in understanding. It is an investment into the youth and even every other person who is not privy to such detailed information. So I think it's a beautiful thing. I would stand back and listen. Probably in a short while, I could come back and tell you a bit more about COPDEM, while you can check if our guests are in or if any of them is around or somebody wants to add more on the subject matter. But thank you so much, Imo State. You guys are great. You have not, when I know they carry last, I beg. Thank you.
Okay. Thank you so very much, sir. Thank you for the short lecture. I really appreciate. Okay, Sir Courage, please, you can go ahead. I'm so sorry. It looks like your network was cut off. So I invited the national chairman to talk to us, but you can go ahead now, sir.
Okay, thank you very much. Sorry, my network went out. So, as I was saying, the rights we have under Chapter 2 of the Constitution are impotent in nature because they are not enforceable in courts. Because of Section 6, sub 6C of the Constitution, which ousted the jurisdiction of courts to entertain matters arising from Chapter 2 of the Constitution. So thus, whenever any right under Chapter 2 of the Constitution has been violated, it is difficult to go to court to claim you want to enforce such right. However, this doesn't mean you are handicapped as a citizen of Nigeria or even as someone in this country. It doesn't mean you are handicapped. Remember, I told you guys that we have two categories of rights. Now, the second category of rights is where we are going to dive into, which is the rights under Chapter 4 of the Constitution. And those rights are justiciable. So, for the record, know that Chapter 2 rights of the Constitution are non-justiciable. In other words, they only serve as objectives in which the government intend to, fulfill. So that is why the heading of Chapter 2 is fundamental objectives and directive principles of state policy. So from that, you see that because of Section 6, subsection 6C of the Constitution, you cannot enforce the rights under Chapter 2 of the Constitution. So because they are ambiguous, it even involves rights to education. So imagine dragging the government to court because your village doesn't have a primary school or secondary school. It may be awkward, and it may be, yes, you are enforcing your right, but the court says you cannot carry the government to court if they violate anything under Chapter 2 of the Constitution. However, it is left for the legislatures to decide in issues where the government's actions are inhumane and can be construed to be gross misconduct. When the government's violation or breach of fundamental rights, whether Chapter 2 or 4, are construed to be gross misconduct, legislatures can impeach the governor or the president, as the case may be. Now, Chapter 4 rights are justiciable. These are the ones you can take to court. These are the ones you can use to tell a fellow colleague or any other person we shall see in court. These are the rights. So it ranges from Section 33 of the Constitution to Section 44 of the Constitution. From Section 33 of the Constitution to 44 of the Constitution they are called fundamental rights. Under the Constitution, they are called fundamental rights. They are called fundamental rights. While Chapter 2 rights are called fundamental objectives and directive principles of state policy. Now, from the historical purview, from jurisprudential aspect, after First World War happened, Second World War followed suit, which was from 1939 to 1945. Now, by the end of the Second World War, there was a need to have what you called human rights. So the concept of human rights, although it originated in ancient time, but it was popularized in a world purview and palace. It gained universal appraisal after Second World War, because what happened in Second World War was too rude, was too harsh, was too brutal. That was when some certain acts were declared as crimes against humanity, which includes genocide, mass murder, and the rest of them. They are called crimes against humanity. Such stuffs, even war crimes, this kind of violations of human rights could take you to the International Criminal Court, the ICC. So the International Criminal Court would gain jurisdiction over such things when they happen at the international palace. Now, when Second World War was over, the rights began to come in generations. We call them generations of rights. So there was the first generation of rights. The first generations of rights is what is also known as civil and political rights. And this same first generation of rights, known as civil and political rights, is what you have in Chapter 4 of the 1999 Constitution. They were termed civil and political rights because they are deemed to be sacrosanct and fundamental to human rights. Second generation of rights also were on board, and those ones were called social, economic, and cultural rights. And those social, economic, and cultural rights, another name is second generations of rights, and they are what you have under Chapter 2 of the Constitution. So you see how the dichotomy of rights came. You had the first generation and second. You had the civil and political rights on one hand, which another name for it is the first generations of rights, which under the Constitution they are called fundamental rights. So the Constitution did not use the word fundamental human rights. Take note. There's nothing like fundamental human rights under the 1999 Constitution. It is fundamental rights. They are the ones deemed fundamental in Nigeria. So it's not like fundamental human rights. It's not used in such approach as fundamental human rights. Every right, both Chapter 2 and Chapter 4 rights, are fundamental human rights, but the ones under Chapter 4 of the Constitution are fundamental rights. Now, the ones under Chapter 2 of the Constitution, under the Constitution, it is called fundamental objectives and directive principles of state policy, which is second generation of rights. Now, under the Universal Declaration of UDHR, of 1948, the UDHR of 1948, it documented all these rights in one instrument. One instrument. When I mean instrument, I mean one law, one book, one written document. They were all documented in one written document. But these documents they were documented into as one written document. That is why it was called Universal Declaration of Human Rights. Inside that document is where you had the variety of rights which have now been dichotomized in our legal system, both civil, political, economic, social. It contained all 5: civil rights, political rights, economic rights, social rights, and cultural rights. However, after the 1948, the ICCPR came on board, an instrument, ICCPR, in 1966, because there was this argument by world powers whether all rights should be treated equally because of the resources to enforce it. That is why in Nigeria adopted these rights but did not treat them equally, because on one hand, there is a need to enforce one category than the other to Nigerian political thinkers. But in some countries like South Africa and I think Liberia, there is no dichotomy of rights. All rights, both civil, economic, social, cultural, and political, are equal. All of them are justiciable. They go to court. If a government is failing in right to education, they can sue him to court. Right to good working standards and working conditions, they can sue him to court. Right to provide electricity, they can sue that government to court. But in Nigeria, if government give you electricity, they don't give you electricity, after month end, what they know is that their bill is going to be increasing. You and I know is a fact. And you cannot go to court and say they have not given me light for 7 months or 7 years. Why are they giving me bill? You will still pay the bill last. So this is how funny it is. You cannot go to court and enforce it. It's non-justiciable because Section 6 sub 60 said those kind of rights are non-justiciable. Social, economic, and cultural rights cannot be justiciable. You cannot go to court and enforce it. You don't have a claim. Although there have been arguments that the court should take judicial activism in making sure that those rights are also enforced, because the concept, there are some scholars that believe that human right is to be applied in whole. Because if you look at the preambulatory paragraphs of the UDHR, the ICCPR, which is the ICCPR here means International Convention on Civil and Political Rights. Then you have the International Convention on Economic, Social, and Cultural Rights. That is the ICESCR. This ICCPR and ICESCR were both made in 1966. But this is why dichotomy of rights started. They were the first international instruments that dichotomized rights. So the ICCPR says their rights called civil and political on one hand. The ICESCR said their rights called economic, social, and cultural. And they should not be treated equally. As a matter of fact, even though countries have adopted UDHR of 1948, countries can adopt ICCPR separately and still adopt ICESCR separately. So the UDHR was not made to divide rights, to have divisions of rights, but the ICCPR came and divided these rights, saying that there are some rights called civil and political on one hand. ICCR said there are some rights called economic, social, and cultural on one hand, so that the gravity of both should not be the same, because the ICCPR are fundamental. They believe it is more fundamental to the socio-economic and cultural rights. So, which we shall see subsequently as we are diving into it now. So now, I want you, the reason I took you to the historical purview of human rights is for you to know that the rights that are in chapter 4 of the Constitution are traceable to the ICCPR, which is traceable to the UDHR, Universal Declaration of Human Rights. Also, the ones in chapter 2 of the Constitution are traceable to ICESCR, which is traceable to the UDHR. Now, under your chapter 4 rights, it is justiciable. Any of your right under chapter 4 that is breached can go to court. I gave you an example of right to compensation when we started. And right to compensation is in chapter 44. It is the last fundamental right you have in the Constitution. That if you are not duly compensated, you can seek a high court for redress. The high court would redress the issue. Now, if you look at the the chapter 4 rights, section 33 provided for right to life, which is not what we're going to talk about, so to say, but we'll see it as it relates with a particular concept. Section 34 provided for right to dignity of human person, that every person shall be, every individual is entitled to respect for the dignity of his person. And accordingly, it went further to say no person shall be subjected to torture or inhumane or degrading treatment. Paragraph B says no person shall be held in slavery or servitude. Paragraph C says no person shall be required to perform forced or compulsory labor. You understand? So if you see section 34 of the Constitution, it gives us right to dignity. When I was still a student in human rights class, Professor Obiareri Nana, he said that the right, I said it earlier today, that the right to dignity of a person, it is the precursor of every other human right you have today stems from right to dignity. Imagine I have a right to own and acquire property. Remember, if I have a right to own and acquire property, if I have a right to own and acquire property, now the law has says this property, let's say a car, you bought this car. The law has says you have a right to own and to acquire a car, that is to buy a car. So you also have a right to own that particular property. Now, it is because of I want to be respected. John Locke, in his jurisprudential thoughts, John Locke said people form social contract theory in order to keep their properties. That the reason why people form the social contract theory is a theory of jurisprudence that states that people came together and gave their right to a sovereign who should rule them. Now, according to John Locke, he said people came together and gave their right to a sovereign to rule them, but the purpose of coming together to give their right to a sovereign to rule them is to protect their properties, because everybody in a society has property. So it is the right to property that made people join social contract. So because I have this, I have that. That is why I entered into a social contract with the state, gave my surrender all my rights to a sovereign who now prescribes laws and rules in order to protect our property. Because I need to be respected, because I want my right to property to be respected. That is why the law gives us right to own property. You see, I told you every right stems from dignity. Remember, dignity, the most decent understanding you can have of dignity is respect. Respect given to a person. Now, if I have a property, you ought to respect the fact that I have a property. Whereby you don't respect the fact that I have a property and you take down my property, I can charge you under criminal law for stealing. Now, if I don't want to charge you under criminal law for stealing, I can charge you under civil law, that is the law of tort, for conversion or debtony, as the case may be. So I want you to respect the fact that I have property. That is why the law gave us right to own and acquire property. Now, I want you to respect the fact that I am a human being and I am breathing. That is why the law gave us right to life. I want you to give us right to freedom of movement. I want you to respect the fact that I am a married man and I have children and you should not interfere in my family issues. That is why the law gave us right to private life. So you see that every right you have came from respect, because the law wants everybody to be respected in different angles or areas of life. That is why the law gave those areas rights, gave you rights in those areas, so that others will not what tamper on these rights. Now, for the concept of activism and social justice, we find it very, very prevalent. We are not talking about some fundamental rights under that chapter 4. You have section 38 of the 1999 Constitution. And section 38 of the 1999 Constitution provides for freedom of thought, conscience, and religion. Section 38 of the 1999 Constitution gave you, it says you have a right to freedom of thought, conscience, and religion. This is where the topic is getting more deeper and interesting. Now, you cannot perform activism without, if you don't have a right to your opinion. If you don't have a right to your opinion, you don't have a freedom to keep opinion, to form opinion, right? So your right to thought, right to think, you cannot perform, because if the law says you don't have a right to think on your own capacity, except the state thinks for you, it means that whatever you think now, if it's inconsistent with what the state thinks, is void. So the law says, because you're a human being, nobody can take away these rights for you. They are inalienable. And the concept of inalienability has to do with, you cannot sell it, you cannot give it out. You were given to it by nature, and when you die, you go with it. You cannot transfer this. I cannot give you my leg and say, take my leg and start walking, start enjoying my right to freedom of movement. Or transfer my brain to you and say, take my brain and start walking, start enjoying my right to freedom of thoughts or conscience. Or take my wife and say, start enjoying my right to personal life. No, these things cannot be transferred. They are non-transferable rights. So that's why they are called inalienable. It cannot be deprived of you. It cannot be derogated of you, except where circumstances allows for exceptions, which are reasonably justifiable in a democratic situation. Now, section 39 gave us freedom of expression and the press. That means everybody, under section 39, it says everybody is entitled to freedom of expression, including freedom to form opinion, including freedom to hold opinions and to receive and impact ideas and information. Just for instance, now we are in a Zoom meeting. I am here educating on activism issues. Now, youth activism. Now, I am impacting on you people. And section 39 says that I have a right to impart ideas and information without interference. Section 39. As you see, we are here now learning. You go to class, you learn from people in your social and daily lives. You learn from people who educate on one thing or another. You see that you are learning things, and it is a right that everybody has. You have a right to learn. You have a right to give out ideas, so long as those ideas are not bad or illegal. So I am here now educating you people now. Now, this right I have now to give you people idea is under the constitutional right of section 39. Everybody is entitled to freedom of expression. I have the right to express myself. That is why when people are treated wrongfully or ways inconsistent or that derogates them their standard of dignity, you see that they can tell you, now allow me to express myself. I don't like what you did. You're an evil person or you're good. All these things are rights you enjoy because you have a right to express yourself. That's why you see most lawyers these days, human rights activists, most of the lawyers that are human rights activists always hammer on expression because they express themselves freely. They believe this right is something that is absolutely possessed because it has to do with freedom of expression and the press. And this freedom of expression and the press, that is why you see today we make laws that encourage press freedom so that the press themselves, the mass media, will not be under censorship of the government. So that the government will, because this right says without interference, you have the right to use these things, freedom of expression, to impart ideas without interference. So if the press is not independent, if the press is being censored by the government, there's interference there. That is why today many people make laws we make laws like Freedom of Information Act of 2011 is a novel law that is also gaining impact. You see that it was a law that purports to make law for the benefit of the press, for information by the press to also not be restricted, so that when the media gives us information, we can rely on it. Now, it goes further to Section 40 and tells us that we have a right to peaceful assembly. Now, this is the bedrock. This is the key constitutional section. Section 38, 39, 40 are the key constitutional provisions of the topic that we have today. You cannot enter into activism if you don't have right to express yourself. Remember, for you to enter activism and say, end bad government, end bad this, end bad leadership, you must have had the right to express yourself. I don't know if you get it. So if you don't have the right to express yourself, how can you start activism? You cannot enter or engage into activism because it is illegal at the time of even beginning it. It is declared illegal at the time of beginning it. So you have Section 39, Section 38 right, freedom of thought. You think, you have a right to think about whatever is happening. If the country is going bad, you have a right to think. You have a right to your conscience. You also have a right to express yourself under Section 39. You have a right to peaceful assembly. Peaceful assembly. So whatever thing you are doing, you must have peaceful assembly. This one now is something very, very fundamental. Whereas if a right you are exercising under Section 40 of the Constitution is not a peaceful assembly, it becomes a riot. The opposite of peaceful assembly is a riot or an unlawful assembly. So there is riot, there's unlawful assembly. You see that in Section 69, 70, 71, and 76 and 77 of the Criminal Code of 1990 of Nigeria. Criminal Code of 1990 of Nigeria. Section 69 defined what riot and unlawful assembly is. It says an unlawful assembly has to do with people who have come together to form an intention that is bad or unlawful. Then whereas where those people are now acting in a way that puts fear in the society and cause unrest in the society, it becomes a riot. So when you are going to do activism, be properly guided. Don't go with sticks and guns and say you are doing activism. It is not activism. It can be construed by your conduct to be an unlawful assembly or a riot. Remember, I told you these rights are fundamental. They are justiciable. But whereas you are going freely, they are not holding sticks. They are holding all these banners and all these flyers and posters. End bad government. End this. End that. End brutality in the state. End child abuse. End child trafficking. End what have you. You see that all these things now, they are peaceful. And if the government wants to or tries to suppress your activity, this activism you are doing, is enforceable against the government. Remember, I told you it is justiciable. Section 46 of the 1999 Constitution tells you that all rights under Chapter 4 of the Constitution are justiciable. You can go to court and enforce it if somebody is violating it. I gave you an example of the Land Use Act issue that the National Assembly made a law that ousted the jurisdiction of high court or any court to entertain land issues with compensation. But Section 46 says you can go to a high court. Section 46 says anybody who fails, his right is being or likely to be contravened by the provisions of this chapter, may seek a high court in that state for redress. So the provisions of this chapter, I've told you, the chapter here is chapter 4, and it is fundamental right. So from section 33 to section 44, any of those rights that are violated, go to high court. High court will welcome you and entertain it. Remember section 17, sub 2E of the same constitution says the impartiality, the independence of the court is guaranteed. The independence of the court and its impartiality is guaranteed under law. So, and access to court is also guaranteed. So, go to the court and tell the court, see, this right has been violated. I don't like it. This right has been violated. The court, if upon the preponderance of evidence, see that these things are true, the courts will now enforce the right for you. So, fundamental rights are serious issues. In the whole world, there is nothing that is gaining more effect and social change in the whole world than fundamental right activities. That is why everywhere in the whole world, you see human right issues. Marginalization is a human right issue. There is nothing that's happening today now that affects human beings. That is not a human. Poverty is a human right issue. It's an attacker on human rights. When somebody is poor, he's deprived of many rights. If you are poor, you don't have right to education. If you are poor, you don't even have a right to access the court because you don't get money to go court. If you are poor, you don't even have right to own and acquire property. Nobody person will get money to buy property. If you are poor, how will you even have a family life? Because now money you go is married for. So if you are poor, you will be deprived of many rights. Many rights. That is why when things go high in the country, we clamor for inflation. It's because we don't want to go to that state of being poor. Because if we become poor, we'll be deprived of many rights. You know, when you are deprived of many rights, the government will use you as they please. You become a rag to them. So you become voiceless. You become a toothless bulldog to the government. So you see that when you are talking about activism, bear in mind that there is a legal appreciation and appraisal of this right. At the same time, there is a legal obstacle. That legal obstacle is that you must not be engaged in riot. That is why when people protest in this country, most times the first thing the government do is to declare that protest a riot. That is the only way they can keep the people quiet. NSAS is a good example. Remember, NSAS started peacefully. But because the government now started shooting on the people, so to say, this is a hearsay evidence. So to say, because of the government started shooting on the people and killing its masses, people started resorting to violent protests. And you know, violent protests now become unlawful society or assembly. And also, it is a riot. And because the government knows that when they push you to somewhere, you will retaliate with force. Now, when you retaliate with force, you have no option than to stop what you're doing because even the court will tell you what you're doing is unlawful. So they had to use that thing as a device, a trick to stop NSAS. When they started killing people, end police brutality, NSAS, end this, end that. You see that when people started protesting freely, goodly, no ulterior motive. The whole motive and intention was just free SARS. Just tell SARS to stay out of the road. In short, if possible, kill that department called SARS. But the government started backfiring on the people. And when the people now said, well, let us do back now, because remember, sovereignty belongs to us. Section 14, sub 2B says sovereignty belongs to the people. And when the people now decided to exercise their sovereignty, the government did what? Declared them unlawful assembly, declared them rioters. They were declared riot. Some people were even apprehended and tried in court. Even people that were not even up to legal age, minors, were tried. And this is a grave violation of human rights. Grave violation of human rights. So when you think of activism, you try to speak up. Yes, we know you have a right. So, but we know you have a right to exercise your freedom of speech. We know you have a right to dignity of human person. Nobody should treat you less human. We know you have a right to peaceful. It is called, the Constitution called it peaceful assembly. Constitution says peaceful. It did not say unpeaceful or disturbing assembly. It says peaceful assembly. So it is a right you have. You can assemble with others peacefully. That's why assemblies like social assembly, like schools, markets, events, shows, all these maybe celebrity shows and stuff like that, they are peaceful. But when the assembly you're assembling it has a motive to kill or do bad things, it becomes, disturbing and unlawful. It can be a riot or unlawful assembly, as the case may be. So, and if you look at the penal code, it doesn't take a funny face to riots and it. So, if the penal code in section 70 says the punishment for unlawful assembly is 1 year, but the punishment for riot is 3 years. Section 70 of the criminal code says punishment for lawful assembly 1 year, punishment for riot 3 years, 3 years imprisonment. Then if you were rioting, section 76 says if you are rioting and you demolish buildings or machineries or railways or other things that are of social benefit, you are going to be imprisoned for life. So why you make up the mind that you want to be an activist or this and that, you have to do it in a way that is permissible by law. Otherwise, what you are doing is illegal. Bear that in mind. It must be permissible by law. When you riot, when you have an unlawful assembly, you are going to be imprisonment for a year. But when your unlawful assembly or when the assembly you have is a riot, you'll be imprisoned for 3 years. However, section 76 says if your riot destroyed things, you'll be imprisoned for life. You'll be imprisoned for life. But if you demolish, but if your riot injured one or two things, you will be sentenced to 7 years imprisonment. So while you injure things, maybe you injure buildings, injure one or two things, 7 years. But when you demolish a building or demolish a railway or bring something to the ground, imprisonment for life. So don't think of it is my right, because every right, section 45 of the Constitution says that your rights can be limited, that nothing shall invalidate any law. Nothing shall invalidate any law which is reasonably justifiable in a democratic society. Section 45, it says nothing in section 37, 38, 39, 40, and 41. And I have given you, the sections I gave you included 38, 39, 40. Right? So it says 37, 38, 39, 40, and 41. Nothing in this section shall invalidate any law that is reasonably justifiable in a democratic society. He now said paragraph A under that section 45 sub 1 that if that law is done in the interest of defense or in the interest for public safety, public order, public morality, public health, or for the purpose of protecting the rights and freedoms of others. So you see, when you see this for the purpose of protecting the rights and freedom of others, section 45 sub 1b is when you have that common phrase that they say where your right stops, another person's right starts. So don't think because you have a right, you can use your right to trample on another person's right. You have a right to freedom of movement. You know, when you enter my land, I will sue you for what? Trespass to land. You have a right to freedom of own, right to own and acquire properties. It's not when you steal my property, I will sue you. You have a right to own, doesn't mean a right to steal. So don't misconstrue things, okay? So the knowledge I want us to have here today is that when you think of activism, don't think of it from a purview or from an angle where you think it is an absolute thing to do. It is something that is without legal restriction. So when you want to enter into activism, the essence of activism is to cause social change. Primarily, I told you, everything you have today, every social change today were products of activism. Every social change that affects public at large are products of activism. And there are some instances which had occurred. There are some instances which had occurred of recent that had caused social change. If you look at instances that had occurred of recent, when you see there's this thing called the free periods. You see, something that happened in Britain. It says there's a girl called Amika George. Amika George, a British teenager. She started free periods movement in 2017. Remember, I told you people that one voice alone cannot cause social change, right? It cannot cause social change. So she started free period movement in 2017. So to end poverty, to end period poverty in UK. So period poverty, the period here, we should take the period there. The period here means period of ladies who are in their menstruation circles and stuff like that. So the menstruation period. So the purpose of that activism was to end period poverty, because some girls go through a lot. Whenever they're in their period, they could suffer some financial loss, and it can affect their status quo of finance. So she started it in UK 2017. She organized a protest outside Downing Street. She established a non-profit to educate about period poverty, and she petitioned the government to offer free period menstrual products in schools. In 2020, her efforts resulted in the UK government providing free period products in all English schools and colleges. So you see that a girl started it alone, but a protest followed it, a peaceful protest, not riot. It followed it in 2017, and 3 years later, in all UK schools, there's what you call free period money. The government give them allowance. The government give them menstrual products for their free periods. So for them not to be using their money to be buying period, things that they would need to take care of themselves during periods and stuff like that. So aside from that, there's one called uh uh the climate strike, which there's a girl also called Greta Thunberg. Greta Thunberg. She's a Swedish teenager. So this one was in Sweden. She began striking outside the Swedish parliament in 2018. She began striking outside the Swedish parliament in 2018, demanding stronger action on global warming because it had to do with climate issues. So she demanded that there should be actions taken for global warming. Her movement sparked worldwide strikes. You see how our movement alone now caused worldwide, people around the world started going on strikes also for global warming issues, for climate situation. And this thing, people went on strike just because of they want their government to focus on it. Because there are times where astronauts will tell us one or two things about the climate situation, and government can be reluctant to it. So we want to make sure the government make sure that our environment is also good and conducive for us. So people started going on strike worldwide, where millions of young people protested. You see, by not attending school or work, a lot of young people protested. They took actions not to attend school. We will not attend school until you pay attention to the climate change issue. We will not attend school until you pay attention to whatever that we are protesting for. The government must hear our cry. Some people stopped attending work. So you see that her tenacity and single-minded dedication show that it is possible for youth to inspire change, not just locally, but globally. What she did, it is possible for youth to inspire change. When you have activism with the right motive, the right intention, and the right, coverage of law, under law, you are doing it in a way that is permissible by law. I put it to you that there is nowhere you will not shake. As far as you are with the aura and fire to do it, there's nowhere you wouldn't shake. There's nowhere you wouldn't shake. Also, there's a thing called March for Our Lives. March, normal march, MARCH, for our lives. Now, in the aftermath of a tragic school shooting in Parkland, students at Marjory Stoneman Douglas High School rose to national prominence as they turned their grief into a worldwide movement for stronger gun control legislation in 2018. They networked with students across the US, organized a massive March for Our Lives protest in Washington, D.C., and created an influential advocacy organization that continues pressing for change. This example shows that the victims of a system of failure can become powerful agents of change. A system of failure. Hey, this line is very, very interesting. It says, this example shows that the victim of a system failure can become powerful agent of change. So in this situation of March for Our Life, the children of the school, they were marching for their life because the way people, the police people, the people you have entrusted gun to are no more using it to protect you, but are using it on you. So these people had to protest, to march. They said they called it March for Our Life. They were just marching, marching around the school, marching around the city. But they collabed with other students across the United States. They marched for their life. They say we are marching for our students. And this thing influenced the legislation that was made by the US government, which also influenced advocacy. They made a stronger legislation for gun control in US 2018. So you see, the concept of advocacy should not be misconstrued or misinterpreted with what it is not. What it is not. So when you think of advocacy and activism and the rest of it, don't think of it from a purview of you have a right you can utilize the way you want. You cannot utilize these rights the way you want. It is something that you utilize with proper care and caution, because in as much as the law gives you rights, it gives you limitations to those rights. Section 45 is a very good example that your rights can and will be limited for the purpose of public safety, public peace, public morality, and also for the purpose of making sure that you don't use your right to abuse the rights of others. So, having noted these little things, we will see just a few obstacles to or a few things that have been hindering advocacy in our systems, and one of them is censorship of the government. The government censors a lot of things. Some things you want to do, the government, like censorship of the press, so to say, because we know the press owe us. Even the press is under a fundamental obligation by law to make sure that they hold government accountable. Where government fails, they ought to hold government accountable. You see, Section 22 of the 1999 Constitution. That section says the press should hold government accountable and responsible to make sure that the government live up to their expectations and policies they owe to the people of Nigeria. But the government censors press. Sometimes the news you see on the media, you'll be seeing one news, maybe you see CNN, maybe something happened and 30 people died. CNN will show you, maybe for instance, 2 killed, as many injured. You see another news, NTA may show you 5 dead, as 3 bodies yet to be found, and how many bodies are injured. You see different information. You don't even know what to rely on, what to believe on. And these things can cause, people to interpret, to get the wrong, this thing can cause people to get wrong information and protest on wrong things. So when sometimes the government censor the press, yes, sometimes they say they censor press to reduce panic in the society, but the press shouldn't be censored. Because when the press gives us accurate and right information, we know what we are working with, we know what we have at hand. Sometimes the censorship of the press can even deprive us from news that we should even protest against. There are some localities in this country that are being strictly and strongly marginalized. Even oil spillage is in their rivers. Oil spillage is in their lands they should cultivate on. You have oil pollution everywhere. So, and sometimes the government, local government, whatever allocation, don't even used to go to them. You see, they live in abject poverty. You enter some village, you see some people, their head is bigger than their whole body. Kwashiorkor and stuff like that. All these things, the press, if they don't cover it up, we cannot engage in youth activism for these people. Remember, we are supposed to be our brother's keepers. So if we don't know what is happening, the government censor press to cover all these kind of stories, you see that sometimes we will be even losing the primary things we should be engaging in activism for. We keep losing the purpose of it. We start engaging in activism for things that are irrelevant. Maybe they can change National Assembly. They can change as they have changed. What is it called? The Nigerian national anthem. You see, some people say, Hafa, come, let's go and start protesting. We want the previous anthem back. Is that something you should protest for when you have people dying in communities that the press is not covering their story because the government has what? Covered it, has sealed it in order to steal or cover their illegal and wrongful doing. So you see that we should censorship of the press is something that we should be sure if we can advocate for the press to be free. I'm sure that we will know the right things to engage in activism for. Another thing is poverty, as I earlier mentioned. When somebody is poor, when you don't have the financial willpower or financial capability, it will be difficult for you to engage in activism. Very, very difficult, or even to protest, because some things require you, transporting yourself from one place to another. Also require you creating an awareness, even sensitization programs. All these things require finance, and when you don't have finance, it becomes a strong and serious barrier, an obstacle to youth activism. Another thing is another obstacle to youth activism is there's this ideology we have. If you are not from my tribe, you and I have nothing in common. Igbo people should do themselves. Hausa should do themselves. Yoruba, I wouldn't lie, I've seen where an Igbo boy in my secondary school, since SS1 to SS3, there's an Igbo boy and an Hausa boy. They are the best of friends in that school. When I mean best of, till today, my secondary school, it was the first time I told myself an Igbo man can work with an Hausa man without problem. But you see, when they are killing Hausa people, Igbo people feel reluctant. Igbo people feel reluctant. We feel reluctant. We feel because we have already formed this idea in our mind that we cannot help them, they cannot help us. These things would affect the way we respond or the way we make activism. We want to make activism we make for ourselves. Even when this thing is traceable to history, when Nigeria wanted to have independence, Nnamdi Azikiwe said he's advocating for the independence of Nigeria as a whole. Obafemi Awolowo will say no, I'm advocating for only Yoruba people. Another thing you're doing, do it for yourself. Nnamdi Azikiwe said, no, let's advocate for the whole country. Awolowo will say, Chief, I'm advocating for my tribe. Now Yoruba, I want to set free. Nothing concerns me and Nigeria. All these things are ethnical barriers that we've created for ourselves. And they are very, very bad and wrong. Another obstacle to youth activism is also the issue of governmental control, so to say, governmental control. Because the government most times uses the executive arm, police and armed forces to silence us, to silence the people who are supposed to engage. When you want to come out to protest, that's why you see sometimes if people want to protest, they will say, who go start them first? Sometimes you see a family, with all of them in that family, one person will say, or in the community, come, let's go and protest. Everybody will go inside their house because they are scared that the government, if you come out, they shoot you. You move, I shoot. You move, I shoot. All these things joined together, they affect our activism. So what is the right method? What is the right way forward? We have to start engaging in activism, not just physically and also, but online. Partnership. We have to start engaging in partnership. Collaborations. These are things that even with international organizations, because international organizations will be, although their principles are guiding international intercourse or international relations, principle of non-interference, principle of sovereignty and equality of states and stuff like that under international law. But then, when it happens to be human rights issues, severe human rights issues, there's always interference. Human rights issues, there are always interference. So when there is serious human rights issues, you see that international community would interfere. The UN can interfere. The ECOWAS can interfere. The AU can interfere. These are things that when we start entering collaborations and partnership with ourselves or with other countries and other international community, we gain more hands, we gain more support. Even finance and the rest of them can come from there. Some people can be aiding you one way or the other. Some people can even be the ones that are aiding you, even publicizing your issues in their country, so that their government also would be aware of what is happening in your own country. Because human rights issues are things that shouldn't be taken for granted. Sometimes the judiciary approach is also very bad. Because, for instance, now, remember I told you Section 2 rights are non-justiciable. Sorry, Chapter 2 rights are non-justiciable. The judiciary's approach to that Chapter 2 rights is also discouraging. It is also an obstacle. After, of course, these restrictions are obstacles to the enjoyment of human rights, and this also includes the enjoyment of activism as a right. Because when you say there are some rights that cannot be justiciable, in other words, you are saying that any right under Chapter 2, if we come out today to say we want to do a youth activism on that thing, we are wasting our time now. Because last, if we protest finish, it's not left for government to do or not to do. A government don't do, we cannot sue them to court. Imagine we come out and say we want to end child trafficking, or we want to make sure, hey, we are protesting to make sure that every community has at least one primary school, or every local government has a university. When you protest finish, you go home and drink your garri, because the government will not answer you. If the government doesn't answer you at the end of it, you cannot take them to court. It is a strong obstacle. So I think with these points I have utilized, we can appraise and understand the topic of youth activism. In the NSAS period, it was something of marvel, something so great, something so strong, something so good, which should have caused a very good change. But however, like I said, one of the obstacles is government intervention. The government intervened and called us unlawful societies, called us this, called us that, rioters. Same thing happened now last year, even when we were protesting because of the inflation of things in the country. And very dark man, very dark man became more notorious in the country because he carried everything, he took everything personal. Even when he accused Wike of being the one firing at government house Abuja when they were protesting, put tear gas in their eyes and stuff. You see that the government always sometimes intervene, but we should advocate for press freedom, because the press, if we can start from press freedom and win press freedom, I think we'll win every other thing. The sovereignty that we so claim belongs to us would come closer to us day by day, because the press is the fourth pillar of democracy. It is the pillar of democracy. It's Section 22 empowers the press of the Constitution, empowers the press to always make sure that the government are held accountable and responsible to the people for their action. How can the press do this when the press is being censored by the government? It is what the government said they should say, that they will say government can give 1 million naira for project and the press will cover 18 billion for project. And we will not know, and we still cry inferior projects everywhere. The money they give, we know see, because the press is being censored. But if the press are not censored, we will know real facts that happen in the country. And then activism on what to do as youths and what to not do as youths would be something that we can revolutionize and institutionalize the way we want it, the way we think it should work for us. So I think I am, to this extent and degree, done with the lecture of the day, which came impromptu for me to educate on. And thank you. I would still be online to entertain questions from anybody or anyone before the meeting is over. Thank you very much.
Okay, sir. Sir Corey, thank you so very much for this great lecture. I am overwhelmed. I'm so happy. I mean, the notice came so late. And man, you'll be giving this lecture for like an hour, 30 minutes or thereabouts. I am so much very grateful, sir. I am very, very grateful. Thank you so much for this lecture, sir. We at COPDEM Students Chapter are very, very grateful. Thank you so much, sir. Okay, if you're watching us live from our YouTube channel, we want to thank you for following us through this lecture. We appreciate those that made out time to join us. Also, we're also live on Facebook. Do well to follow us on Facebook at COPDEM Imo State Students Chapter. Do well to follow us, and thank you so much. Okay, please, is there anyone in the house that has any question for Sir Courage before I call anyone at all? Okay, in the absence of any question, Sir Courage, I'm very grateful, sir, once again. At this point, Pastor Lawrence, our program coordinator, please, you are very much welcome, sir. Thank you so very much for joining us today. Good evening, sir.
Probably he's unable to mute, or mute rather.
Okay.
Pastor Sir
Okay, then.
Lauren.
Hello, my national chairman. Good evening, sir. Yeah.
Evening.
Good evening, everybody. God bless you. We're happy for the program tonight. Though I'm still busy with so many things. I just came in, and thank you so much for the lecture. God bless you.
Okay, thank you so very much. National Chairman, sir, any words of encouragement for our speaker? I think he did a very, very nice job tonight, sir.
In fact, a very good job is an understatement. This is inspirational. And the way he was going about it, he was just gisting it out and quoting constitutions here and there. My goodness. So we have such young talent in Nigeria. These are the kind of people that COPDEM is gunning for to present to the House of Representatives come 2027. Other developed climes, they're not waiting for the whole Senate to be filled with old people. I can remember when I was in my school, there's a kind of ideas I was generating. And there was less work to do. We had more time to engage. We had more time to reason with each other. Well, after school, you get married, you are far in this, you begin to pay school fees. Before you know it, you are focused on a different path, survival. But the young people have energy on their side. They have beauty on their side. They have intellect on their side. They have the advantage of technological expertise, much more than the older generation. So why can't we have such people step forward? In fact, this is one of the basic reasons why COPDEM went into alliance with ADC, the African Democratic Congress, so as to create a corridor for young people to move up. We have people, of course, like Badmos, a young girl, but right now in the parliament abroad, if we can excel to that extent. Well, I may not agree with all her positions, but at least it shows that Nigerians have something and Nigerians are respected. It is a wonderful thing. I will encourage and see that let's have this kind of discussions across all the COPDEM's university or tertiary institutions forum. It's going to, it's going to make people know their rights. It's going to make people know their responsibilities. It's going to make people know their limitations or where their boundaries are. And so when they want to express themselves in a social activist way, they know what to do and what not to do. They know when to pull back and when to sit down. These are things that will make people have confidence. I can assure you that a lot of people didn't want to come out for the August protest or when the elections were mad and stuff like that, because if you come out, they go shoot you. But now we know they don't have to shoot you if you are not a rioting crowd. And you have every right to be confident to sit down where you are and express yourself with your placards, peacefully demonstrating and calling the attention of your employee, which is anybody within the ranks and file of paycheck that is coming from the Nigerian government. It is we, the Nigerian people, that are paying their salaries and paying their fat allowances that is getting them 20 million naira a month. So these things should be encouraged. This is really awesome. This is wonderful. So Pastor Lawrence, let's see how we can re-invite the young, courageous man, so aptly named, to come back, probably on this forum again, maybe in a week or two, so that we can hear more and share more. Not for violence, but information is power. In fact, I feel so rejuvenated. So well done, our chairman of COPDEM, Imo State. You have done a wonderful job. Courage, you are an asset. And Dynamite, the leaders of Nigeria the next 2, 3, 4 years. Don't put down your guard. Keep this good work. On behalf of COPDEM, we say we are really proud of you guys. We're proud of Imo State and proud of this presentation. Thank you very much.
Thank you so very much, sir. Thank you very much. The words are encouraging. Thank you so very much. Okay, I think with all this being said, we can, come to the end of the program. Like I said, for those watching us on live on YouTube, we have a Facebook page that you can, like and follow us. Thank you so very much. Pastor Lawrence, I'm grateful, sir. National Chairman, sir, I'm so much grateful. Okay. Sir, the host, I'm also grateful, sir, for having me on board and also helping me with the resources to, make this program a success. I'm so much grateful, sir. And I promise that more discussions would also be coming up. More discussions like this would also be coming up. I feel it's also a way to, sensitize more about our COPDEM projects. Thank you, everyone. Thank you, everyone. Good night, everyone.
All right, good night. Thank you very much.
Thank you, everybody. Good night, everyone.
Oh, thank you. Wonderful.
Yeah, good night, everyone.